Welcome to the Hopeful Divorce. I'm Hope, your family law friend. After working in family law firms for many years and watching thousands of divorces play out, I've learned some things about what does and doesn't work, and I'm here to share.
This question is from the Divorce Women subreddit. Separating and finances. My common law spouse and I have lived together for 4 years. We bought a house together and have a 2.5-year-old. We do not share finances. He pays the mortgage and I pay all the bills. His income is higher than mine, $160K. Mine is $82K. I've always been an avid saver and have a good chunk of money saved that he doesn't know about. He might have money saved too. I honestly have no idea. I know this isn't a typical relationship, not speaking about finances, but that's how it's evolved and we're both okay with it. I'm thinking about leaving. He's a heavy drinker, not abusive or unfriendly, but the amount of which he drinks honestly disgusts me. I'm not attracted to him and have no desire to be with him anymore. I want to propose separating, and I would like half the value of the house and 50-50 custody. I don't want spousal support or any of his assets. Has anyone in Canada gone through a separation divorce without having to disclose finances? My biggest fear is that he would get some of my savings, which I worked for and saved while he wasted money on booze. This is an excellent question, and I'm so happy to have it, because common law marriage in Canada is very different than marriage and divorce. And how you separate if you have a common law marriage is very different. The way that property is divided is different. Now, in Canada, divorce is handled by the Divorce Act, which is a federal law. So the federal government handles all divorces in Canada, and it's all the same. But if it's common law marriage, it depends on where you live, in which province. Not all provinces recognize common law marriage. And certainly, I know a lot of states do not recognize common law marriage. So wherever you live, if you are in a common law situation where you are living together like you are married, but you are not actually married, it is extremely important that you talk to a lawyer in your area and find out how it applies in your case, because this varies widely. Now, I'm going to talk about Ontario because that's where I am and that's where I'm familiar with the laws. Now, the provincial law is called the Family Law Act here in Ontario. And it sounds like, from what this woman says, that she should apply. She is considered common law married. Here you have to live together in a serious committed relationship for 3 years. Or if you have a child together that has been born or adopted while you were together, then it's 1 year together. So they have a child and they've been living together for 4 years. So they probably meet the standard of common law marriage in Ontario, and they own a house together. Now, if both of their names are on the house, then it is very likely that she will get a 50-50 split. Generally, when it comes to common law marriage, it goes to just property rights. So it goes to who's on title. And if you're both on title of the house, then it should be split evenly. However, if her name was not on the house, it's still possible that she could have a share of the house. Maybe not half, but she still should be entitled to some share of the house if they have been living together in a common law relationship. It gets a little complicated to determine exactly what her share would be. So I'll just give you some examples. Now, in this scenario, the example that she gives, she was paying the utilities and he was paying the mortgage. So she definitely, if her name was not on the title of the house, she would definitely have some level of interest in the house because she was paying for maintaining part of the house. She was also living in it. She was also taking care of it, presumably. And so all of those things, you can have an interest in it. Also, maybe she did some things like some improvements to the home. Did she paint all the walls? Did she pay to install new carpets? Did she add a deck onto the back or build a garage? These kinds of things. A lot of times people, who are living common law, they'll make improvements to the home, which improves the value of it. So now they have an interest in the home. It's called a constructive trust. And that's just a legal term. What it means is that a trust is an agreement. So it's saying like, I'm investing my money into this house to improve its value while I'm living in it. So we have an implicit agreement that I have a share in the house. It's kind of like, your friend wouldn't just come over and like build a garage at your house and give it to you for free and expect nothing in return, right? There would be some sort of compensation, some sort of ownership interest in most of those cases. Now, maybe somebody would just give you a gift. And sometimes in common law situations, it is clear that there has been a gift. And it has been clearly stated that it was a gift, that adding the garage was a birthday present. And there was no ownership interest, but you would have to prove that in court if the person filed a trust claim on it. So when both names are not on the home's title, it gets a little more complicated. And even if you have been living in the house and you haven't contributed financially in Ontario, you still could have an interest in the home. If you were living there and not working, but you were, particularly if you were taking care of children while you were living there, or even if you weren't, if you were just taking care of the home and mowing the lawn and cleaning and maintaining it and, calling the plumber when a plumber needed to be called, or I saw a case once where a woman, did not have children, but she took care of the home and her common law spouse did not drive. So she would drive him to work and drop him off and pick him up every day and took care of the home. And she did have a common law interest in that house. The court did rule on that she had a share. She didn't necessarily have a 50-50 share in it. It's always it's a little more complicated. It's complicated, and it just depends on the facts of each case. So you would have to talk to a lawyer in that scenario to find out, whether or what kind of interest you might have in the home if your name is not on the title. Now, the other thing she talked about was her savings and if she would have to fully disclose and if she would have to give him some of her savings. For the most part, now this is not absolute, but for the most part, her property is going to be hers and his property is going to be his. That's generally how it goes in a common law separation. If they're separate accounts, they're not commingled and so forth, then most of the time they just stay separate. And there's nothing to worry about it. But a case could be made. There are some situations where maybe it was. Let's say, for example, he was paying the mortgage, he was paying the utilities, he was paying the groceries, he was paying for every single expense that they had. She was paying for none of their living expenses whatsoever. And she had this job and she saved up a whole bunch of money because she wasn't paying for anything while they were living together. He could say, look, the only reason you were able to save all that money is because I was paying for everything and you didn't pay for anything. So there are some scenarios where you could put a claim on the separate property of a common law spouse. There are some situations, but usually, that's not how it goes. I mean, it just depends on the facts of the case, but that is possible. Now, she said that she doesn't want spousal support. In Ontario, she would probably be entitled to spousal support. The reason why is they've been together for 4 years, so they meet the definition of common law. And I'm making an assumption here, but she probably took time off when their child was born. In Ontario, most women take at least a year off. And so she would have been probably earning a lot less money, even though you get some benefits while you're on maternity leave. It's probably not the same $82,000 income that she was earning. And so during that time, she sacrificed for the family so she would get some spousal support, some compensatory spousal support. But, they were only together for 4 years. So it's not like she'd be looking at a long time of, receiving spousal support. She might also, just because of the sheer difference in their incomes, he makes almost double what she does. And so because of that, she might be entitled to some spousal support in just the short term to kind of help her get on her feet after they separate. So, what I would recommend to her in this situation, instead of going for spousal support, and what I would recommend she do first, of course, is just talk to a lawyer. and find out exactly how much spousal support she would likely be entitled to based on the facts of her case. Like I said, all of these things depend on exactly what happened in her case. But she probably gets some spousal support, and she should have that estimate. She should say, I'd be entitled to this much per month for this many years. It would be about this much money. And then, either you'd say to him, like, look, I don't want spousal support. I could get, this much money in spousal support, but I'm not going to ask for it. And I'm just going to ask that we go our separate ways. You could do that. But, I would say that it's not a bad idea to advocate for yourself. Maybe what you could ask for is say, look, I'm not going to ask for spousal support. I'm entitled to this much in spousal support, but instead, would you just pay my security deposit for my new place for me and pay for my U-Haul, my moving expenses? Like, up to a certain dollar amount, like give me $1,000 towards my moving expenses. I'll send you the receipts and you can reimburse me for that. And, I've found a new place to live and this is how much my security deposit's going to be. So would you please pay for that? And I'll just waive spousal support. Which is that's probably going to be a lot less than the amount of spousal support that you could be entitled to. It would depend on the math, but I'm just using that as an example that in a case like this where it's short term, you're probably not going to get a lot of spousal support for very long anyway. And, so forth. Maybe just ask for something else that's kind of small as a way of, waiving and moving on and saying, you know what, your debts and your assets are your business. Mine are mine. I just need a little help with moving expenses and I want half the house. That sounds like a very reasonable thing. And if he were to go talk to a lawyer, he would probably find out that that's a good deal and that you don't need to worry, about doing all of the disclosures. It's not absolutely mandatory. But you can ask for it. Disclosures can be a part of it. If he wants to find out because he is concerned that there's a constructive trust, he's concerned that you have a whole bunch of savings that you got because he was paying for everything or something like that, he can ask for it. But in most common law situations, you don't see a lot of disclosure because it's not like in a divorce. In a divorce, you have to have all of the assets really crystal clear because they all get equalized. And there's not equalization in common law marriage. You don't have that same kind of things. There is some division of property, and there is some compensation, but it's not like when you get divorced. Now, the other thing you mentioned is that you want to do 50-50 parenting time. And, that is, of course, what the courts default to. They generally like equal parenting time because the child has a right to access to both parents frequently. But you will be having child support in this case if you have 50-50. He makes $160,000. She makes 82. And if you have a parenting schedule where it's 50-50, then he will be paying you child support and you will not be able to waive it. That is something that the courts are very adamant about. You cannot waive child support. It is the right of the child to receive that child support. So, and based on your incomes now, if she made 82,000 and he made 90,000 and you had equal parenting time, well, then, you might be able to just set child support to 0. It wouldn't be waived and it wouldn't be gone. It's just that because everything is equal, you're canceling each other out. But if his income suddenly went up or if her income suddenly went up or suddenly went down, then child support would be a factor. And the law in Ontario does say you are supposed to send your notices of assessment to each other every year and update each other on your income so that child support can be evaluated. That is the law. And so it could change over time. But in this case, definitely it would be some child support would be paid because your incomes are very different from each other. Taking a quick pause in today's episode to remind you, this podcast is built around your questions. If you're navigating divorce, separation, property division, child support, custody, co-parenting, blended families, or anything in between, you don't have to figure it out alone. Chances are, if you're wondering about something, someone else is too. You can submit your questions anytime through my website at hopefuldivorce.com. Whether it's a big, complicated situation or a simple, what does this legal term mean, or why does this happen this way? All questions are welcome. I read every submission, and your question could be featured in an upcoming episode to help not just you, but others going through similar experiences. So if something's been on your mind, send in your question. Let's keep the conversation moving forward. This question is from the Legal Advice Canada subreddit. My ex-husband and I have been legally separated for 8 months. We can file for divorce in October. Today, he told me he intends to apply for a job outside of his current field that will result in him making about $30,000 less than he is currently at the beginning. Right now, neither of us pays the other any support because we make similar money annually. But he's saying that if he gets this job, then next year, after our taxes are done, he's going to file to get child support from me. But he can't do that, can he? He's proven that he is capable of earning a similar salary to mine. So why would I have to support his career change? This is a great question, and it's a very common scenario where one parent has a change of jobs and it impacts the child support situation. Now, of course, as always, you have to talk to a lawyer in your jurisdiction to find out the nuances. This is in the Legal Advice Canada subreddit, so I know that it's in Canada. I'm not certain of the province. So we're just going to talk about in general terms how child support generally works. But of course, there is nuance in every jurisdiction, so it's important to talk to a lawyer. But in general, the short answer is no, you can't just quit your job and expect your ex-spouse to pay child support in order to make up that gap. Or you can't be willfully underemployed, choosing a job, just taking a high-paying job and quitting that and then getting a job as an entry-level job at minimum wage, for example, and then saying, see, now you have to pay child support. You can't do that. The laws generally work that both parents have a responsibility to financially support their children to the best of their ability. Now, how it works here in Ontario is that you have child support tables, and the tables offset each other. So how that would work is if parent one makes, let's say, $100,000, their child support, and I'm just making these numbers up. These are not real. I'm using simple numbers for an example. If parent one makes $100,000 and they have to pay $1,000 a month in child support. Parent two makes $50,000, and so they have to pay $500 in a month in child support. So they would cancel each other out, and then the parent who makes $100,000 would have to pay $500 to the other because they get a credit for the $500 that the one who makes $50,000 works. So that's how it goes. So in some circumstances, if the parents have less, as long as there's 50-50 or less than a 60-40, like if it's 55-45 in terms of the parenting time, and if they make the same income, then they can cancel each other out, and then it becomes zero. But it's not that there's no child support. It's that you're both supporting the child and they happen to cancel each other out. That's something that I think a lot of people get wrong. They think that if you have equal parenting time, there's no child support. And that's not how it works in Ontario. You each have an amount that you're responsible for paying. And then if you have, equal or almost equal parenting time and the same income, then it gets set to zero. But that can change at any time, because if your incomes change, then it will change based on that. So there is no waiving child support. Child support is always going to be paid, but occasionally it's set to zero because everything is equal. Now, can you quit your job and change careers and take a pay cut? Well, maybe. Maybe it depends on the circumstances. The way the law works in general with family law, and pretty much any law and when it comes to family law, it always gets down to what is in the best interest of the child. That is always the guiding principle on every single law. And when it comes to child support, there could be a scenario where one parent would work only part-time so that they could be available to care for the children after school, particularly if you had a special needs child. And so working full time and earning a full income that they could get would actually be detrimental to the child, because having that parent only work part-time or work not at all because they're very young, because they're special needs, or because of some other circumstance that it is in the best interest of the child, it is okay for a parent to be underemployed. But you have to make the case that it is in the best interest of the child. Now, if this parent is making $30,000 less and they have a very clear plan that it is going to result in something much better for the children because of taking this pay cut, if they can make that case, then child support may be ordered. It would really get down to the facts and to the judge, and you would definitely need to talk to a lawyer before making a move like this, because it's not necessarily automatic. The parent in this situation is saying, I shouldn't have to fund their career change. And that is true. It's not. Now, child support is the right of the child, and you can't just refuse to pay it. But if this parent who made a career change went to court and asked for a court order, I would recommend that this person fight it and say, he's capable of making this amount of money, and I ask the court to impute that income to him. And what that means is saying that, look, you've proven you can make $30,000 more. So in terms of the court order, I'm asking the court to just pretend like he's making that, and it will incentivize him to actually make that amount of money. Courts do that all the time. For example, if a parent has no job at all and they're not taking any efforts to get him to become employed and they are willfully being unemployed, the court may impute income to them and say that you have to pay, whether you have a job or not, you have to pay this amount of support because you're capable of earning it and you are willfully not trying to get a job. So the court would make a decision on that amount based on either they might set it to minimum wage because they can assume that that person can at least earn minimum wage, or they might look at their employment history and what they were earning before and then set it to that amount. It would really depend what the judge, but it's called imputing income. And the courts will do that because they take the responsibility of a parent to support their child to the best of their ability is very serious aspect of family law. And courts are very quick to order people to pay child support because it is the right of the child. The child deserves to be financially supported by both parents. This woman, what I would recommend she does is that she talk with her husband instead of just waiting for things to go to court and getting that. Ask for a mediation session or ask to, sit down with them and just talk about it and say, why are you making this career change? We both want to do what's best for our kids. So why are you taking a $30,000 pay cut? Is it because you just want to follow your dream and do this different thing? That's not necessarily in the best interest of the children. If you were still married and living in one household and you decided to make a career change, well, that might be something that a family decides to do. But when you have two households, the impact on the children having the financial reduction of an income going down, it hits harder because it's more expensive to have two households. So the standard for just being able to change careers when you have two households, you've got to be able to prove that it's in the best interest of the children. But I would recommend that she talk to him about it. Find out what the goal is. Find out what the plan is. If this person is certain, feels very confident that it's going to, because he said it's going to be about 30,000 less in the beginning. So maybe he's making this career change because he's going to be able to make even more later. And if you find that out, you can maybe work out some sort of a plan on how that's going to work. And I would definitely get some legal advice in this situation. Do not rely on ChatGPT or information on the internet. Child support varies a lot by jurisdiction, and it also varies a lot, just depending on the specific facts of the situation.
Thanks for listening to The Hopeful Divorce. If this episode was helpful to you, share it with someone who might need it, and be sure to subscribe so you don't miss future conversations. And as you deal with challenges of separation, divorce, and rebuilding your life, always remember the wise words that Christopher Robin told his friend Winnie the Pooh. You're braver than you believe, stronger than you seem, and smarter than you think. Until next time, take care of yourself and keep moving forward.